India is a landmark legal battle that addresses the complex intersection of intellectual property rights and public health. It revolves around Novartis's application for a patent on its drug, Glivec, a treatment for certain types of cancer, which was rejected by the Indian Patent Office. The dispute highlights significant issues regarding access to essential medicines and the balance between corporate profit and societal welfare. At the heart of the case lies India's Patent Act, particularly Section 3D, which stipulates that new forms of known substances must show significant enhancement in efficacy to be patentable. Novartis argued that Glivec represented a novel invention, as it was a new crystalline form of imatinib that demonstrated better stability. India, however, contended that the drug was not significantly different from the existing form and was merely a modification that did not meet the stringent requirements for patentability. The Indian Supreme Court delivered its judgment on April 1, 2013, ruling in favor of the Union of India. This decision underscored the importance of access to affordable medication, particularly in a country where millions suffer from diseases like cancer and cannot afford expensive treatments. By denying Novartis a patent, the court emphasized its commitment to public health and well-being, asserting that patents should not stifle the availability of crucial medicines to those in need. The ruling generated significant reactions globally, proving to be a pivotal moment in the ongoing debate surrounding patent laws and public health. Proponents of the decision heralded it as a triumph for public health advocates and access to medicines. They argued that it would encourage the production of generic drugs, making life-saving treatments accessible to a wider population. Conversely, pharmaceutical companies expressed concerns that the ruling could discourage innovation and investment in research and development of new drugs. In conclusion, Novartis AG v. Union of India serves as a crucial precedent in the ongoing dialogue about the balance between patent rights and ensuring public health. The case highlighted how legal interpretations of patent laws can profoundly influence access to medicines and set the stage for future legal battles in the realm of healthcare and intellectual property. The implications of this case will continue to resonate in discussions about drug accessibility, affordability, and the ethics underpinning patent law globally. Did you know that this landmark case was pivotal in shaping India's patent laws, allowing for the production of affordable generic medicines that save millions of lives? Novartis AG v. Union of India. Others is a case that has far-reaching implications for the pharmaceutical industry and public health. At its core, this case revolves around the tension between patent laws and the need for accessible medicines. As we delve into this complex and fascinating story, you'll understand why it's a crucial chapter in the ongoing debate about intellectual property rights and their impact on humanity. The significance of this case cannot be overstated. It has been hailed as a major victory for public health advocates, and its effects are still being felt today. But to truly appreciate the importance of this case, we need to understand the context in which it unfolded. So, let's set the stage for this gripping narrative. In the early 2000s, the pharmaceutical industry in India was thriving, driven by a plethora of generic drug manufacturers. These companies were instrumental in providing affordable medicines to millions of people, not just in India, but across the developing world. However, this growth was predicated on a legal framework that was still evolving. India's patent law, which was amended in 2005, posed significant challenges for multinational pharmaceutical companies like Novartis. Under the new law, patent applications were subject to stricter criteria, and the definition of inventiveness was narrowed. This meant that companies like Novartis faced an uphill battle in securing patents for their products. In 1997, Novartis filed a patent application for its anti-cancer drug, Glivec, in India. The application was initially rejected, but Novartis appealed the decision, sparking a prolonged legal battle. At the heart of this dispute was the question of whether Glivec was a novel invention or simply a modified version of an existing compound. The case eventually made its way to the Supreme Court of India, with Novartis arguing that the patent application should be allowed under Indian law. On the other side, the Indian government, supported by various public health organizations, contended that the patent would restrict access to affordable medicines. As the Supreme Court deliberated, the stakes were raised and the debate surrounding intellectual property rights and public health reached a fever pitch.